The father of the Oxford High School shooter appeared in Oakland County Court today. James Crumbley's attorneys are asking the judge to keep certain evidence from being presented in his upcoming trial.
The defense has also asked for a change of venue. Today's hearing, though, focused on arguments over witnesses that the prosecution plans to call. One being the original owner of the gun used in the shooting, and also the judge will allow that, plus 2 students injured in that shooting.
Don't we have a video of that?
We do have a video, Judge, but and the video obviously is extremely relevant, extremely important, because the shooting is why we are here. And when we have actual eyewitness testimony available, it is important for the jury to hear that perspective.
The primary purpose of their testimony is to inflame the emotions of the jury. I mean, their testimony or whatever they can provide can also be provided in a video. The whole purpose of admitting the video and not having sound on the video was to lessen the prejudicial impact on the jury.
We should note that Crumbley has on headphones because he says he's hard of hearing. The judge will be ruling on whether or not the students will be allowed to testify and the other motions presented. Now, this hearing comes ahead of his involuntary manslaughter trial, with the jury selection in that case set to begin on March 5th.
Earlier this month, his wife, Jennifer Crumbley, was convicted on 4 counts of involuntary manslaughter for failing to prevent their son from committing the Oxford High School shooting in November of 2021. Joining us today are attorneys Terry Johnson and Lillian Diallo. Thank you, as always, for being here.
Thank you.
Terry, I'll start with you. This feels familiar. We saw some very similar, some of the exact same requests from Jennifer Crumbley's attorneys, many of which were not granted. Do you see any differences between what James is asking for and what his wife did?
I don't see any differences. The big thing here is, if Judge Matthews were to change course and direction, I think it would set up major appeals for Jennifer Crumbley. So I don't see that happening, and even the change of venue, it is a, I understand the request. I would have made the same request, especially going second, but I don't believe it's going to be granted. Again, you have to be tried by a jury of your peers. And a jury of your peers are not people, let's say, in Escanaba or Traverse City.
I do want to ask, on the publicity note, though, is there any chance the added publicity of Jennifer's trial, which we just got through, is there any chance that lends credence to the attorney's argument?
It would lead credence, but again, the question comes back to jury selection, and during jury selection, Judge Matthews is going to ask, as well as the attorneys, you know, can you put biases aside and make sure that Mr. Crumbley gets a fair trial? And if they answer yes, we can, that's pretty much good enough to keep it where it's at.
Now, Lillian, at the end of Jennifer's trial, we had questioned what kind of moves James's legal team would try to make as a result. What do you make of them bringing these questions that they are bringing forward about the change of venue and also some of the witnesses that we're seeing being presented?
Those are great, sound pretrial motions any defense attorney would make. Change of venue. What is venue? Well, does the court have the jurisdiction to hear? Well, yes, we know they do. But is this the best location to hear these particular facts? I don't know. I mean, there's so much publicity out there. You just have to hopefully get a jury that's going to honestly answer your questions and say, I can be or I cannot be fair. But the lawyer is doing what the lawyer is supposed to do in this case.
Yeah, the attorneys are also asking the judge to exclude information about the son's mental health, text messages, journal entries, if he does not testify. And it certainly seems like he's not going to. We've heard that. We didn't see him testify during his mother's trial. So at any point, Lillian, can the shooter be compelled to testify?
Not one way in this world, as long as there is a Fifth Amendment right to self-incrimination, and he still has appeals, and his lawyers have indicated that, right? And the journal, I think the defense is on the right track. I cannot cross-examine this journal. If you let this journal in, they're going to take this as true, right? So, I think they're on the right path. I do not understand that journal. Also, if in fact he does not testify, go to that Miller hearing, and hopefully he was under oath when he said he was telling the truth, and it says, my parents had nothing to do with that. He's unavailable.
And they
under
can
the
use
court.
that as evidence?
Absolutely. Under the rules of hearsay, right? In the 800s, the rules of evidence, go right on in there and use that, because he is unavailable. Once you're unavailable, you can use sworn testimony or something, a statement, sworn statement. Come, bring it on in.
Now, Terry, one of the sticking points today was whether or not it's relevant to have those students who were shot and survived testify. His lawyers were saying it's not relevant to the fact that this is a manslaughter trial and he's not the one who carried out the shooting. What are your thoughts on that?
I actually agree with the defense attorney, and you know what Lillian just said is spot on. You know, the defense attorney is doing what a defense attorney should do in terms of pretrial motions. This particular one is inflammatory, bringing people on because none of these people know or have probably ever seen outside of the court hearings Jennifer or Jason Crumbley in this. I mean, let's face it, this is used to inflame. And even the soundbite that we heard earlier when the defense attorney said correctly, we've even allowed video in with no sound so not to intensify or inflame the jurors. So I think it's the right thing. And let's briefly go back to the previous trial. There were some things that were let in that defense attorney said, yeah, we're just going to let it in. Hopefully this defense attorney doesn't follow suit, and you might see a different trial.
Things that she had previously asked to be excluded.
Exactly. That doesn't mean that they're going to come in for this particular trial, but I hope not, because I think it was very damaging in the last trial.
Yeah, the fact that we have such a different defense attorney even already, do you think that that could possibly alter the outcome?
Well, again, you know, I think it could alter the outcome. Do I expect it to? Probably not. But again, you may have some different facts and different, you're going to have 12 different people. Again, there are 4 of us here and we probably see things 5 different ways, right? So we never know till those 12 people go back in that room and decide what they're going to do.
Yeah. Lillian, do you think there will be any impact from Jennifer's trial on James, or should there legally?
Well, I think there will be some kind of impact, right? I would say, to Terry's point, and this is what I tell people, different attorney, sometimes you get a different result because everybody approaches it differently. I'm kind of puzzled about why you would let somebody that owned the gun before come in and testify. I don't know what that's for. And I will be honest, I've been in court all day, so I have not been following this very closely.
I believe reportedly it had something to do with the cable lock and figuring out what condition that lock was in
That's irrelevant.
prior to it being sold.
That's really irrelevant. I mean, the question is, if it's involuntary manslaughter, again, which I still have problems with the charges, the fact that the cable lock was or wasn't working doesn't matter because it's not like he took the gun with the cable lock to school. I mean, let's not go down that road. I think it's ridiculous.
So legally, it sounds like both of you are agreeing that we need to make sure that we're keeping it in terms of what James had to do with what was carried out ultimately.
Absolutely. And, you know, I would probably use certain things, you know, admissions by a party opponent when Madam Prosecutor said, this was unthinkable. Yes, it was. How could my client have thought of this, right? That something like this would have happened. I mean, it is egregious, though. I mean, it's absolutely horrendous that you have 4 dead children who did nothing wrong, right? So, I mean, you have to present your case, Madam Prosecutor, and I'm not mad at you for prosecuting. And as I've said, I know Terry disagrees with me about this, right? I think this is the gift in voluntary manslaughter as opposed to child abuse, because had they have charged child abuse, it would be felony murder, and that's life without the possibility of parole ever. Understand that. So I know, you know, people have it either way and they see it differently, but the gift, because we know there are 4 dead people, it's what is your culpability here, right? Is there anything you, James, could have done? Or was the wife the boss of the house who tells you, get up, do this, do that, do this. I don't trust you to do that. We don't know. Yeah.
One of the most notable moments in Jennifer Crumbley's trial was when she herself took the stand. Do you expect to see James Crumbley take that stand?
I would hope not. I would hope that the defense attorney would do everything in her power to get his testimony and his position in without him taking the stand. When someone takes the stand, it rarely works out because let me tell you, James Crumbley is sleeping in the Oakland County Jail. He's under stress. He's not going, no matter how much you prepare him, he's not going to be prepared for a skilled prosecutor in cross-examination. A little slip up or even a wrong question, like I've heard from so many people with Jennifer Crumbley, when the question was asked, would you have done anything different? How do you answer that question? That's like, do you still beat your wife, right? How do you answer that question? Because if you say yes, you're guilty. If you say no, you're not showing remorse. So, but I wonder if we're going to have a plea deal before this goes to trial.
And that can happen at any moment. It doesn't need to be offered by the prosecutor?
Well, I don't know what's been offered and what hasn't, but you know, one of the things could be, listen, we can do a sentence agreement. You know, let's say instead of 10 years, let's save everybody money, let's save the pain of the community, the whole 9 yards. He'll do 5 years. That, you know, I don't know, but there could be some negotiations going on like that.
Yeah. Well, we will see. Again, jury selection in James Crumbley's trial begins March 5th. Terry Johnson and Lillian Diallo, as always, thanks for being here.
Thank you.
Thank you.